Vivek, am I sharing my screen? Can you see it?
Perfect.
Great. Thank you, everyone. Let me jump right in. So to segue from John's talk, we're going to talk very briefly about the roadmap from lab to launch. A lot of this may be redundant for some of the other things you've heard about. There'll be some details in there otherwise. And then I want to talk about the foundation of patent strategy to help you as academics understand why this is an important process and what happens at the company stage, because that will inform your decisions in the IP creation in the academic setting and your dealings with your tech transfer offices. So there's obviously a difference between working with your university and a company. If it's your research, you need to file your patent before talking with outsiders. I mean, these happen. I like John's slide where he kind of showed that everything is very chaotic at times, and that's almost always how it happens. There's no singular formula that occurs, but best practices are to file your patent before talking with outsiders. You may end up talking with outsiders by necessity, but if you do talk with outsiders, you create the risk of releasing prior art that could be used against yourself and your own future patents. And also you seed other people's minds with what you're working on. And there's a lot of value in that. You're going to know a lot more technically than they are usually in most situations with respect to your research field. So being able to file the patent and show that you knew what you knew when you knew it is important. Your university is likely going to file a provisional application if they do file a patent on your research. A provisional application will last for 1 year at the patent office. The patent office doesn't do anything with it other than just stamp it received and start a clock. But it will act as a priority document for future patent filings. So if you then convert it at the end of that year, if there's a dispute about when you came up with something, they can go back to the provisional applications needed to use it as a reference, a proof that you did come up with what you came up with when you came up with it. The problem with this 1 year time frame is that the race is on. So as soon as you file it, you want to try to get the business going up to speed. It takes a lot of time to do all these things, as you can imagine, to get funding to provide the university with incentive to convert it to a non-provisional application. There may be international filing expenses that occurred that year as well. And so there's a tug of war between not wanting to file too early when you don't think you're going to actually have enough in place to convert it in a year from a business perspective, and not wanting to file it too late where other people may come up with your idea and get filing priority over you. As most people know, in 2013, the US changed from a first to invent to a first to file priority system. So the filing date of your patent application is very important. So getting that filed and retaining the right of the priority of the provisional is critical. Academics, I don't think I've ever seen an academic-led company, and I'm sure they're out there, but it's rare. Usually the academic has the fundamental research, and then they need the outside collaborators to get things really cooking. By the way, I should back up and say universities will, and John is really the better person to opine about this, but universities will sometimes convert provisionals, even if the business isn't fully up and running, if they believe there's enough, at least commercial promise in the provisional application. But if it's just the academic working in their lab and they don't have anybody else working with them, it's much harder to get that company going. You as the academic have a full-time job. It takes a lot of time to get companies started, to go get funding, to build teams, and that's not something that you're gonna. It's not really your strength. Not that you can't develop that strength, but it's not your strength to start off with. And B, that takes a lot of time. And trying to do something like that with a full-time job is difficult. So you need those outside collaborators, but then you're sharing information with them, and you may not even have the company formed initially. And even then, what about the conversations you're having with them about the information that you're coming up with? That's why you need to have non-disclosure agreements in place, again, to prevent both potential release of prior art to them, especially if your potential collaborators go off and don't end up working with you, potentially work on some competing device or system. And then also sorry, I may have just said this. So both prevent prior art releases by having a disclosure with somebody who's not covered by a confidentiality requirement, and then also preventing them from going off and just taking your ideas and using them elsewhere and claiming that they're the ones that came up with it. Another best practice is to get an option or a license with your university on your intellectual property as quickly as possible. If you're the one that's going to be part of this company going forward, the earlier you can sign an option or a license with the university, the less expensive it's going to be. Obviously, you still need the cash. Universities will almost always charge you an upfront fee to get the option or the license. Options are usually cheaper, but then you still have to sign the license later on. But the longer you wait, if it turns out to be promising, the more the university is probably going to ask in exchange for the IP. A lot of you may find yourself in another situation where it's not your specific research, or even if it is, it's not your company, and you're just doing consulting, or you have some kind of consulting-like position with an outside company. There, the university is still going to own, in most situations, going to own the intellectual property. Sometimes you're asked to consult in something that's a little adjacent to your research. And I've seen a number of situations where academics will get the tech transfer office from a university to actually release the university's rights with regard to anything you come up with in something that's not related to your research. So it's a conversation to have in the university, because when you start working with these companies in a consulting role, or even in some kind of joint, co-employment role while you're employed at the university, you don't want a dispute between the university and the outside company for IP rights. And if you have the outside company put them in a position where they have to license from the university to get the intellectual property you're coming up with, to get rights to that, you put them in a difficult position. Academic publishing should wait until after the patent application is filed. This is the question that almost always comes up: is does my submission count as the publication? Is that a public release of the information? Submissions to academic journals are usually considered confidential, but you need to check the documentation with that specific journal. In the United States, you're actually granted 1-year buffer time between the publication of your own invention and when it will start counting as prior against you. But outside the US, that's usually not the case. So unless you are working on an invention that's only going to be commercialized in the US, which early stage, it's very hard to predict that. And you should definitely keep your options open. You should be sure to get the patent application filed before the publication of your invention, even if it's buried in an academic publication. Not that you're trying to call out the invention, but if it's in there, that would create prior art issues. And and check the submission rights of the publisher in case they don't have any confidentiality obligation in the submission. And also do patent searching yourself. A lot of academics are a little they misunderstand. Or maybe they've heard from people, you shouldn't search patents for some reason. That's totally untrue. There's so much information in the patent database that you won't find anywhere else. A lot of companies work on technology and keep it confidential except for their patent filings. And those technologies a lot of times don't get commercialized, or even if the company commercializes, there's a lot of information in their patents that does not end up getting commercialized. You wouldn't find it unless you search the patent database. So do a lot of patent searching. The other thing is the early inventors are the ones who are usually most technically understanding of the idea. And you're the ones that are going to be able to best process the prior art that you review and then synthesize it for the other people on the team. Even us as patent attorneys, we rely on the inventors to explain a lot of the information to us. And they always come in with the best, well, not always, but often they come in with a lot of really good prior art when they come in to disclose inventions in the first place. So your knowledge of the prior art should not be limited just to what you understand from the academic sphere or what you see commercialized. What is a patent right? Most people in society don't grasp this, and it's hit and miss with academics, but patents don't give you the right to actually practice anything. Patents only give you the right to prevent others from practicing what's your claimed invention. These are a few pages out of a patent. It's much longer than this, but you can see on the left, there's the cover page. It's got a lot of useful bibliographic information and an exemplary figure. This may not really, even the figure in the abstract may not tell you what the substance of the patent is very well. Those are selected by the applicant, so they can pick anything they want. Then there's a set of figures, as shown by the second page here. there's a kind of a wall of text disclosure as shown by the third page. The figures and the text, the body of the text, are there just to support the claims. You can't enforce the figures and the text by itself, what I'll call disclosure by itself. As John mentioned, you only enforce the claims, but the figures and the text give you flexibility to alter the claims while the claims are being examined. And they also give you the ability to mine your patent family for claims in the future, which we'll get to in a moment. So just because the claims are the only things being enforced, and the claims are often going to be produced either by or at least in conjunction with your patent attorney, it doesn't mean you should skimp on the disclosure. And the disclosure is going to come far more from the brain of the inventor than it is from the patent attorney. And the disclosure should describe a plethora of information, not just a narrow view of what you think the specific commercial embodiment is going to be, especially early on in the process when it's very hard to predict what's going to get commercialized. But in the far right page, that's the last page of the patent, and that has the claims on it. These are numbered paragraphs. Kind of zoom in on one so you can see it a little better. They're really, theoretically, they're just sentences because they have one period at the end of them. But that covers the scope of what's actually going to be enforceable. And if somebody is practicing, if some third party is practicing exactly what's shown on that patent claim, they are infringing your patent. They can do a bunch of other stuff that's in the disclosure, doesn't matter. They can do everything in the patent claim except for one of the words, that also doesn't matter. Neither of those are infringement. But infringement would be when they're practicing the entire claim. So again, a patent doesn't give you any right to practice the invention. It only allows you to stop others. Patent strategy has 3 prongs. Patent strategy is necessary for a company to understand their IP position, and they're going to have to be able to tell this story to others. So the first prong of patent strategy is the patentability analysis. The question being answered there is, what coverage do we have or expect to have with our patents? A lot of times, early stage, let me say, the patent office it could be a very, very fast and with expedited processing, the patent office, you might get a patent issued within about 6 months, but most patents take about 1 to 4 years to get issued. So when you're an early stage company, often you're having to explain yourself to investors or others well before any patents issue. So you need to show that you've done the homework to be able to answer this question prospectively, at least with some degree of confidence. What patent coverage do you expect to be able to receive? What coverage do you think you're going to receive? The second prong of patent strategy is freedom to operate. The question being answered is, what is our infringement risk? These 2 prongs get confused by people who are not experienced with patents yet, because it goes back to that initial statement from the last slide of patents only allow you to stop other people from practicing. So your patentability analysis is only going to tell you what can we stop other people from doing. Your freedom to operate analysis is going to say, can we commercialize this product? Is this thing going to get sued as soon as we drop it on the marketplace? Because if so, nobody's going to want to touch it with investment money. And the third prong is ownership. The question being answered is, who actually owns our IP? And that includes when we're licensing IP, when we're working with other individuals within the company. Have they signed assignment rights over the company? The patentability requirements are that the patent must be novel. That means that whatever it is you're claiming is your invention in your claims, those claims that we looked at, that's what's going to actually be examined by the patent office, and that's what's enforceable. Are those claims unknown? Has there been somebody beforehand that has disclosed everything in your claim? If so, it's not novel. Also, are they non-obvious? So the standard there is that they're not obvious to one having ordinary skill in the art, but that's obviously very subjective. And that's what a lot of the time spent dealing with the patent office comes down to, of getting into a back and forth with the patent examiner, trying to scratch their itch about clearing their subjective non-obviousness bar. But the idea is that you can't just make some minor modification to something that's already known. So if the examiner can come back at you with an argument that he could combine most of your claim from one reference and the few missing elements from a second or possibly even third or fourth reference or fifth reference, there's no actual number limit on how many references are allowed to combine, then it would be obvious. And you have to continue to either narrow your claim during the examination to satisfy the examiner that it's no longer obvious, or you need to argue with them in a way to convince them that they're seeing it incorrectly. And the third requirement is, and I should say these first two are really the quality of understanding these before you go through the examination is going to be based on searching prior art and how good your search of prior art is, which goes back to my first slide. I mentioned you should not be afraid of searching. You should go searching, and your searching will help the understanding of these 2 points of patentability analysis. The third requirement for patentability is to have patentable subject matter. That means you can't just try to patent discovery, and especially in the software realm, you can't just try to patent an abstract idea that's being done on a computer. It needs to be something inventive. Once you file your first application, a very valuable strategic use of the patents are to file continuations. The continuations come off of your originally filed non-provisional application. So your provisional application, as we mentioned, will hold your place for a year, and then you eventually will convert that into a non-provisional application. The non-provisional applications get examined. At any time during this examination of a non-provisional application, you could file the continuation application. You're not required to, but if you have a valuable technology, you absolutely should. That continuation application is like a child patent application that's got to be filed again during the parent application's pendency. That pendency will conclude the day the parent application issues. As long as you filed the child application by the time the parent issues, you can file yet another child, in essence, a grandchild application before the child application issues. And you can file a great-grandchild application while the grandchild is still pending, and so forth. So the use of these is to mine the applications. I mentioned and they all, I should say, they all receive the benefit of the parent's priority. So if the parent claims back, if the parent of the specific child you're looking at, great-grandchild, you're looking at in the patent family claims back to a parent, its parent, which is actually the child of the family, then that will claim back to the original application in the family. And these valuable patent families can go on for the entire term of the patents. The only requirement is that they're filed during the pendency. There are 4 requirements. 2 of them are not really relevant here, but one of them is that they're filed during the pendency of the previous patent in the family, and the other one is that whatever you're trying to claim in the continuation has to be supported by the original disclosure. That goes back to what I was saying. You want to be able to describe things in the body of the patent more robustly than just being targeted to what you believe the commercial embodiment itself will specifically be. Because mining these continuation applications serves some strategic purposes. Number one, in early stage companies, you're very likely going to pivot to some degree from your expected commercialized product. And when you do, you want to be able to write patents that have claims that cover whatever that pivot is. Hopefully your initial patent is so broad it will cover it anyway, but you may have some very specific marketable improvement that you discovered during early R&D, and you want that patent to be able to cover that marketable improvement. Well, it may be that marketable improvement was something you thought of during early research, but you thought, well, it's not really the best idea. Well, it may turn out to be the best idea. If you don't include those not the best ideas in your disclosure of your original patent application, you won't have the flexibility to cover them in the continuation later on when you realize that they actually were more valuable than you thought. If your product's successful, you're going to have next generation versions of it. There's going to be some evolution of your product, because if it's bringing in money, you want to keep improving it to stay ahead of the other guys. And again, you very likely will have some of the insights for what will be in the next generation products early in research. If you don't include them in the patent application, you're not getting priority to them, and you won't be able to cover them in future continuations of your original patent family. And the most valuable aspect of continuations for successful products that have long-standing patent portfolios is to stop competitor design rounds. Because once you have a patent issued, you can't alter the claims. Claims at that point are locked in. And savvy competitors will look at your claims and figure out how not to infringe them by leaving out just one aspect of the claim. And when they do that, if you have not filed a continuation and you're just stuck with your originally issued patent, you can't do anything. The competitor is free to practice then because they've avoided infringement of your patent. If you file a continuation and you've got sufficiently robust disclosure in that, when you see the competitor product come out, your continuation will have a priority date well before the competitor release their product. And you will likely be able to craft new claims at that time with your hopefully robust disclosure support that will cover the competitor's design around it. That's a huge value of continuations. We've had a number of situations where that's what we end up going after the competitor with, not the originally issued patents, but the competitors will utilize some of our original concepts that we disclosed years later in their design around products. And then we will have those patent families still pending, be able to file continuations, and at that point target the competitors once we see how they try to design around. If our original disclosure is not sufficiently detailed, we're going to have our hands tied. International patent coverage. There are two categories of international filings. There's a PCT application. A PCT application allows you to delay filing into most countries on the planet. And it allows you to delay it. I should say also, Taiwan's not included, unfortunately. There are some countries that are not part of this, but most of the relevant countries you care about are going to be part of the PCT coverage. But Taiwan is not part of WIPO, so it's not included. It's particularly important for semiconductor companies, but there are other companies that are specifically interested in Taiwan. They won't be able to use the PCT process. A PCT application extends the international filing deadline up to 2.5 years from your earliest priority. It's useful because these international patent filings create a large cost, and be able to delay that is useful while the company determines where its markets lie, where its competitors are, how much cash they're going to have available for an IP spend. So you don't want to overextend yourself with international filings too early, because you're presumably getting the company going with the hope that it's extremely successful. And if you don't file your patents in time, you're not going to be able to go back later on and file them after you've disclosed information. So you want to retain your priority date for the early patent families in other countries. And you could even use the PCT application to come back into the US. But be able to delay those costs is extremely useful. But the PCT itself does not issue into a patent. It only holds your priority open for 2.5 years. At the end of the PCT process, at the end of 2.5 years, you then actually have to file it into specific national phase applications. National phase application, I mean by that just filing a patent application in individual countries. The US, filing in the US is a national phase application, filing into Japan is a national phase application, filing into China is a national phase application. Patents are only enforceable in their country. So if you only end up getting US patents, competitors can compete with you globally, just outside of the US, without risk of infringement. And one of the initial thoughts people may have is, well, how can they stop people from competing against me? Like, I'm not gonna have the cash to file in every country on the planet. And we worked with some large drug companies who filed in a lot of countries, and even they're not covering the entire globe. And the answer is that you can't keep them from competing against you everywhere, but markets are usually consolidated into a few large countries. I haven't seen the economic data lately, but I remember hearing a while ago that this is probably 15-year-old information, that 90% of the global medtech market was the US, Japan, and Europe. That information is so old at this point, I wouldn't be surprised if it's probably 90% is those and China, and maybe, actually that still might be close to 90%. Obviously, it depends on your specific product you're trying to develop. So there's not a one size fits all rule as far as where people file their patent applications. But yeah, the general rule of thumb is at least you want the early stuff going into China, Japan, US, and Europe if possible. And you would file these specific national phase applications either within the PCT pendency, which is what I mentioned. That's why I use the PCT to delay all these national phase deadlines for 2.5 years. Or if you bypass the PCT, for some reason you don't file PCT, you need to file it within 1 year of the first application. So if you file a provisional in the United States, at that 1 year deadline to convert it to your non-provisional, you actually need to file it into every country you want to file it into if you're not using a PCT. As I mentioned, it's really expensive. You start to multiply the expenses. Not only does each one of these countries require you to pay at filing, some of them require you to pay annuities every year while the patent's even pending. You're going to have an examination in every single country. So you're going to have to pay your attorney and the foreign attorney for every time you interact with the patent office in that country. It gets expensive. Again, the benefit of being able to push all this stuff off for 2.5 years. And countries vary in their laws, both in the way they examine the patents and the way they're enforceable. One example is in the United States, patent enforcement is very expensive and it takes a long time and it's time consuming for everyone. And the flip side is the damages are very high in the United States, and it's obviously a premier market for most technologies. So patent coverage in the United States is very important. China, even though it's got a historically bad reputation for IP, they actually do a very good job now of protecting patents, generally speaking. But their examination process is fine, but their litigation process is very different. There is no discovery there. So the process is very fast and very inexpensive compared to the US, but it's likely just to result in an injunction and not in damages. So in a way, it's strategically beneficial because you can go to China and win a patent infringement suit there and maybe shut down manufacturing if that's where manufacturing is occurring for your competitor. But you also may want to sue in the US to get larger damages. And even then, how, for example, software applications are treated is very different between the US and China as well, and other countries. Patent term, how long does the patent actually last? It's 20 years from the earliest priority date. Now you have to pay the government even after you have the patent issued in order to continue to be able to enforce it. But as long as you make those maintenance fee payments, you can enforce it up to 20 years from the earliest priority date. That does not include the first year of pendency of the provisional application. So if you file a provisional, in a way that kind of extends your patent term. Not officially, but you get a year of priority that's not counting against your patent term. That's very useful, especially for things that need to go through extensive regulatory approval. You'll be able to get that extra year on the back end. The Patent Office switched systems in 1995. They used to give patent applicants 17 years of patent term from the day the patent issued. Now it's 20 years from the earliest priority date. And to make up for that, I think the calculation was it takes about 3 years to get a patent issued, so they would give that back to the applicant. Now, the Patent Office doesn't want to be wholly unfair, so if the Patent Office creates too extensive of a delay during the examination, they'll give back applicants up to 5 years of patent term. So if you are, for some reason, looking at a patent and wondering whether or not you infringe it and thinking it's expired, you want to check to make sure there's no Patent Office extension adjustment on it. That'll be shown on the cover page of the patent. The FDA also can give you back up to 5 years if you have delays at the FDA, but this is much more limited in the availability of getting the FDA extension. There are a lot of limitations I'm not going to get into now. There are only about 1,000 total patents that have had FDA patent term extensions, and there are obviously a lot more products than that have gone through the FDA regulatory process and suffered delays because of it. So that was kind of patentability, the first prong of patent strategy analysis. The second prong is FTO, freedom to operate. So sure, you got the patent, you understand how long it lasts. Now, how do you make sure when you commercialize your product, you don't get sued? Because as I said early on, the patent only allows you to prevent other people from practicing. It doesn't allow you to actually do anything, even if you're doing what's claimed in your patent. So when you're doing the FTO analysis process, you want to start again like with patentability, with a good, robust search. That's how you have better understanding of what's going on out there. There is no examiner to check your work like there is with the patent filing process. So you've got to do this all on your own. It's all about risk control and understanding risk. You want to focus on issued independent claims. If a patent that you find is still pending in examination, it can't be enforced, and those claims you're looking at are very likely to still be amended before they get issued. Almost always away from any concern you have, and so companies that focus on pending claims are usually doing themselves a disservice. You got to filter those results to make sure that they're relevant for what you're working on, and also very likely to be competitors or some other entity that would bother suing you, because it's going to, again, be an expensive process to do that. If you're not in the same marketplace and you never show up on the other company's radar, there's a good chance they would never come after you. And there's a two-step process of the detailed analysis. The first step is claim construction. Most people don't understand that when they read the patent claim, their interpretation of it on its face is not necessarily how it's going to be applied against their commercialized products. Each word of the patent claim will be reviewed by the court if there's an infringement, and those words can have much different meanings than what they seem to have at first glance. They're going to be interpreted by what the applicant says in their own body of their application and what happens during the examination. So just as an example, there's probably somebody here with better physics background than me on the call, but if blue light was, for example, just hypothetically, 400 to 600 nanometers, as far as most experts thought the bounds of blue was, but the applicant said blue was 300 to 500 nanometers in their patent application, and then they used the word blue in their claim. Well, blue will be interpreted as that applicant's definition of blue, which is 300 to 500 nanometers. So if all you did was look at the claim and you thought, oh, what we're doing isn't blue because it's 350 nanometers in wavelength, you're fooling yourself. Because if you actually read through the specification, or perhaps something's occurred in the examination process as well, which is all the documentation for that's publicly available on the online in Patent Office, then the claim is going to have different scope than what you had initially thought from just reading the claim itself. And once you have determined what the scope of the claim is by reviewing the specification, the disclosure of the patent and the file history of the patent, that is the file history meaning the correspondence between the attorney and the examiner during the examination process, then you compare that to your actual product. So are you actually doing everything in the claim now that you understand it? Is that right? Or do you have components that are maybe you're not doing and you didn't realize it unless you went back through and did a detailed word by word check between the claim and your product? So I've been saying that you need to infringe the entire claim. That's actually only one of three types of infringement. That's direct infringement. There are two other types of infringement. There is, I should also say a little side note here about direct infringement. If you have some kind of surgical method, that is exempt from infringement in the United States for direct infringement. So doctors can't be sued for actually practicing a surgical method. And internationally, most countries won't even allow you to patent a surgical method. You have to try to approach patent coverage from a different angle. There's a second type of infringement that's called contributory infringement. That means that the infringer is making a material component of the claim that's not a staple with non-infringing uses. And so one of the examples is that there was a printer company that had a claim with a printer, and they also claimed the toner cartridge in it. And I think the focus of the claim really was about the toner cartridge. And there was a company making knockoff toner cartridges that would have satisfied every limitation in the claim about the toner cartridge, but they never produced a printer with it, and they were just selling the toner cartridge. And the printer company sued them and said, well, you're making a material component of our claim, the toner cartridge portion of the claim, and there's no use for your toner cartridge other than sticking it in the printer. So you're therefore contributing to infringement. And there has to be knowledge that it will be used to make an infringing product. Obviously, that in that situation, somebody making a toner cartridge, there's no way to use a printer toner cartridge other than sticking it in a printer, so they know it's going to be used for that printer. And the third type of infringement is inducement of infringement. And I mentioned that doctors can't be sued for infringement by practicing surgical methods. That's this is how you actually enforce a surgical method claim. You go after the medical device or medical technology manufacturer who's instructing doctors how to use it under their instructions for use. To satisfy inducement, you need to instruct somebody to infringe, such as instructions for use, and know that others will infringe, and then somebody actually has to do the infringement. So if you find that doctors are practicing your invention, you go upstream and figure out why they're doing it. If they're doing it off label, there's nobody to sue because the company that's selling them the technology was not instructing them to do it that way, and the doctors are exempt, generally speaking, from being sued for practicing the method. Once you figure out your infringement risk, you want to make sure to manage it. First thing, obviously, is try to mitigate it. The ways to do that are to design around. Once you identify high risk issues from your freedom to operate analysis, you would change your product, eliminate some element of your product that's shown in the claims of your potential suers, so that they no longer could catch you in infringement. You could potentially license the IP. This is best done very early stage and from a non-competing entity, particularly a university. That's about the only situation. You wouldn't want to go to another company that's competing against you and try to license their IP unless they had you cornered and they're already threatening to sue you. You're also exempted from infringement during regulatory testing. So if you're taking steps to get approval from FDA, then that itself is not infringing. People realize this when you hear about the generic drugs coming out the day after a patent expires. Well, that can't happen unless the generic has already got manufacturing prepped and up and running, and potentially even packaged the product before the patent expires itself. So doing that, making sure the FDA is satisfied with their manufacturing process is necessary. Otherwise, it's effectively extending the patent term for the name brand drug owner. There are some acceptable risks. I hate to say it that way, but that's kind of the best way to frame it. If you're potentially subject to de minimis damages, if you're very early stage, that the regulatory testing exemption is only for actions that you're taking for regulatory testing, but you may need to do some preliminary work on it. You may need to build the product, and patents are able to stop you from making, using, selling, or importing the invention. You're almost definitely going to need to make and use the invention before you even get to regulatory approval, and you're not shielded at that point. But the damages are so low, there's no absolutes, but virtually nobody's ever going to come after you at that point. So the damages are de minimis. It's no problem. So if you find a potentially high risk patent that's going to expire during regulatory testing, even though you may infringe them before you even start regulatory testing, you probably don't have to worry about that patent in the long run. If a third party that has the patent that creates the risk is in another market, like I said, they're probably not going to come after you because you're not affecting their business otherwise. And there are just some unknown risks that you got to accept. Like these things will pop up, and as you're more successful, the risks become more real too, because you get deeper pockets and people are more willing to sue you with edge cases, even if you know that risk is out there, but you don't think it's very strong. It will get stronger just because of your success. Also, as I mentioned, there are these pending applications that get published. They haven't issued yet, and you may be concerned about the state of their claims and where they may end up directing their claims by the time they issue. But you have to accept that there's just stuff out there that you can't plan around, because most likely pending applications will not end up being a risk, even if they seem like it while they're pending. And you'd be just overwhelmed trying to deal with patent risk if you dealt with every pending application out there that you potentially infringed. The quick animation to illustrate the difference between patentability and FTO, because this is often where people get confused early on. Let's say you're working on a company, super simplified hypothetical. You're considering making one of these three products: a bicycle, a penny farthing, or I should say a mountain bike, a penny farthing, or a motorcycle. And there's one competitor you know about in this hypothetical universe. There's nothing exists otherwise. And the competitor was around beforehand, and they make this kick scooter. Well, when it comes to your patentability analysis, you're trying to get some patentability coverage that would potentially cover any one of your products because you don't know which one you're going with yet. You're very early stage. But you can't obviously have a claim that extends into prior art that's known. So you would potentially argue that your claim is going, especially when you're talking to investors or when you file your patent with the patent office, try to claim a single seat attached to wheels. That's your hope for patent coverage. That would cover everything in this circle. And there are a number of other, infinite number of other variations of vehicles that could fit in this circle as well. It's just that it has to satisfy this description, a single seat attached to wheels. That's patentability. Now, from a freedom to operate standpoint, you want to look at what the competitor did. And the competitor may have already filed a patent and already gotten it issued, and their claim may say a wheel less than 1/3 height of the frame. These two circles overlap. So you can have overlapping circles between your patent coverage and a competitor's patent coverage. And that's fine. Like I said, your patent only allows you to prevent other people from practicing. It doesn't give you the right to do anything. If there's an entirely different company here who's trying to practice within the overlap of your circle and their circle, that other company needs permission from both of you to prevent infringing. But once you've done your FTO analysis and you see that you have infringement risk for the penny farthing, you obviously don't want to go forward with that product. Or you can, but it seems like a bad idea to me. So let's say you go make a decision to move forward with the motorcycle design. You drop the penny farthing in a mountain bike. You now have a product that is both hopefully covered by your own patent claim. So if somebody tries to make a knockoff, you can sue them. You can also tell customers it's patented. That always sounds really good. But it avoids infringement risk from your competitor. Well, if the competitor has a continuation pending and they see you do that, they will try to get, if they're smart, they'll try to get a continuation claim that covers your product. So the competitor may drop a continuation claim on you that says front and rear wheels attached to a frame. Well, their scooter has front and rear wheels attached to the frame and there's nobody before them, so they can get that patent issued and that will cover your motorcycle. So you hopefully have not gone too far down the development stage at this point, and you could change your design, try to design around this infringement risk. And here's a potential design around that's both covered by your claim, which is, again, not necessary, but good to have. But more importantly, it is outside of your competitor's patent scope because you've dropped the fact there are front and rear wheels. You still have frame, you still have wheels, but they're not front and rear. Now, we talked about patentability and freedom to operate. Ownership is the third prong of patent strategy. Ownership starts with the inventors, and the inventors are the people who actually conceive what's in the claim, what's in the claims. So anybody that contributes to conception of the claims is an inventor, and they instantly are co-owners of the patent. But they almost always have some kind of ownership transfer to their employer, but the ownership transfers have to be in writing. It's almost always going to be in the employment agreement with your university. At this point, I can't imagine, maybe out there, but I can't imagine there are any universities that don't have IP assignment terms within their employment agreements. Always worth checking. It may have slipped. It may be extra tightly constrained in the way they worded it, but there's almost definitely going to be an obligation through your employment agreement to assign anything you come up with in your, at least in your field or with the university's working on. To the university. If you start a company or you're involved with a company, make sure that everyone involved signs assignment terms, usually with an employment agreement that would be in there if it's done correctly. But you also have a lot of contractors and very early stage stuff, which a lot of academics are involved with. Everything is very loosey-goosey and people are usually, having a lot of informal conversations and then start working together before they sign documents. You gotta buckle down and make sure those NDAs get signed and these IP assignments get signed, because early on, things aren't worth very much. And so everybody's willing to be very collaborative. But as soon as the value starts to become known, people's greed will overtake them. And anybody who hasn't signed anything will be, I don't want to make it sound absolute. I think most people are actually pretty good. But I've seen so many examples where somebody who is collaborating very nicely gets greedy and then the relationships start to fall apart, all because people didn't sign the documents early on when everybody was in that collaborative mindset and thought there was nothing at stake yet, and they were all working together towards a common goal. Now that can be claimed, the amount of IP ownership that can be claimed varies based on state law. Most states have limits where the employers or anybody else, even a contractor, contract relationship, can only claim IP limited to the current or foreseeable business of the employer. And that's even if you use your own resources. So if you're working on your job at home and you come up with an idea related to your job, then the employer will still own it, assuming they asked for that much in your IP assignment agreement, in your employment agreement. If your IP assignment term in the employment agreement is so narrow it excludes that, well, great. They have to ask for it in writing. If they never say it in writing, then you get to own it. But if they try to ask for more than that, they can't have it. And if you use your employer's resources, even if it's not related to anything the employer is working on, the employer can get shop rights in most states, which means that the employer can retain a free license to your IP. Kind of a weird situation, because if they don't have any interest in the thing otherwise and they weren't working on it, they're unlikely to ever utilize their shop rights unless it becomes a really successful product. If you're working on like a dog bowl at home, but your university has nothing to do with that, I'm sorry, if you're getting your dog bowl into your office using university resources, the university may have nothing to do with dog bowls or veterinary medicine or anything. But your dog bowl invention, your university could at least say they get a free license to your dog bowl invention. How they utilize that, I don't know, because again, it's not one of their fields, but they at least can try to argue that they get the rights to it. And the best practice is to file these invention assignments with BTO, but it's not actually required. There are additional rights you get by filing with the patent office. So if you're ever trying to figure out who owns what patent at the patent office, I wouldn't rely on what's shown at the cover page, because the cover page of the patent shows who owned it at the time it issued, but the ownership can transfer during the life of the patent. Patent office has an assignment database you can search separately, which will be updated if the patent gets sold and a new assignment is filed. But that's not guaranteed to be correct, but it is probably over 90% of the time. So due diligence, what happens with IP during due diligence? This will obviously be in situations where there's any kind of investment, particularly private, or, VC investments, angel, seed, ABC rounds, and so on. But that also includes acquisitions and even IPOs. Every one of these stages has kind of different things that are usually focused on when it comes to IP diligence. In licensing, there's also going to be diligence, especially by the licensee, to make sure that the patents they're licensing are strong enough in what they want. But there usually is not going to be much of an FTO component, because unless you're also getting a product license, like the licensor is making the product and just handing off the licensee, then it's up to the licensee to actually make the product and avoid infringement. But the diligence checklist is what we've already talked about. It's the patent strategy list. It's making sure that patentability analysis has been done and is understood and carries value. Same thing with the FTO analysis, and same thing with the ownership issues. Also, the spectrum of rigor of diligence varies tremendously by industry and the type and size of the deal. And I should say in the software realm, it's usually far weaker than it is in the other areas, although it's much stronger in the med tech area. So when you've got software medical technologies, you're kind of this overlap of two different industries, one of which seems to care very little about understanding its IP position, and the other one that cares very much. So it's kind of very hit and miss when it comes to software-related medical products. So a few quick software specific issues. There was a case in 2014 that some people may have heard of that went to the Supreme Court, where they were trying to determine what patentable subject matter limits are for software. They said software must be more than an abstract idea, or if it has sufficient interaction with the physical realm. That second bullet point doesn't mean you're just like swiping on a screen. It means something more along the lines of controlling a robotic arm or something like that. But that's got to be part of the invention too, not just the software can interact with the physical realm. The Supreme Court was very bad about providing concrete guidance on what the word abstract meant. So the patent office has kind of gone, everybody's gone in their own directions. The courts are still making decisions to help clarify this. The patent office has given as best of guidance as they can based on what the Supreme Court said, but you're going to get a lot of variation between examiners and different art units at the patent office as far as what gets through software wise. And what I just said a second ago, software patent culture is significantly, they give a significantly different weight and importance to IP issues than the med tech and the healthcare patent culture, where things are much more taken much more seriously and given much more weight. I think that's a big part of that. I think is that purely software products can have very short life cycles. It's usually they're created with much lower expenses. The med tech products usually take a much longer time to get through regulatory approval and usually need much more investment to actually get commercialized. And so those two timelines and investment requirements kind of have created these two different mindsets regarding IP. You probably have also heard of non-practicing entities, also known as patent trolls. Universities actually fall in this list because they're not creating anything. They're not practicing the invention. They just create the IP. But there are also entities, usually of patent litigators, who will get patents that aren't being utilized or available for purchase from their owners and then go enforce them on potential infringers. This is far more active again in software world because the software companies are not spending as much time doing the analysis of avoiding infringement risk. And so they find themselves walking through a bunch of infringement issues without concern. And I think there are just a lot of, especially when it comes to what you think of as the trolls, a lot of companies, a lot of patent litigators realized this and saw that there was a need for this service really to monetize software patents that weren't being used otherwise. It's expensive to litigate. A lot of patent owners don't have the money or the time or the willingness to sue. And so the trolls kind of stepped in, took over ownership of a lot of these patents and then started suing with these patents that weren't being utilized. And a few AI issues regarding patentability. It's just the same as software. I mean, AI really is just software in the end. And so you've got the same patentability requirements as software. You also have the same novelty and non-obviousness requirements. Doing something that's already known on some kind of generic AI is likely going to be obvious. So just because you're the first person that thought to do it on an AI, unless there's something specific about the model you're using, it's unlikely to be patentable. Inventorship, the inventor must contribute in a significant way to conception of the invention, but AI is really a tool. The inventor's got to be human. Somebody tried to file a patent claiming the AI was the inventor. That's just, in my opinion, silly. That obviously did not get through for them. But like I said, AI is just a tool. It's just a software tool. There's CAD, there's finite element analysis software, there's video processing software. There's a lot of software out there that does a lot of heavy lifting for the human inventor. That doesn't mean the human still didn't come up with something. So the human's got to direct the AI what to do, even at the very early stage. The human's doing something with the AI to get it going. It's extremely complicated version of a wrench if you want to dumb it down. And the other thing is AI law is very unsettled right now. The Patent Office inventorship guidance is still for AI inventorship. It's still based on a 1998 case that obviously doesn't have anything to do with AI. In 2022, there was an AI patent case, and the court didn't even discuss whether AI is patent eligible. And I think it's just because it's just software. People come in and ask, "Oh, can we patent stuff on AI?" Yes, it's software. Let me jump really quickly. Last slide here. Just some copyright tips. So the figure wasn't supposed to. This is kind of like the punchline came up at the beginning of the joke. So a couple of tips if you're working on software, really quick. It's just insert unique comments in your source code. If somebody steals your source code, you want to be able to prove that it was yours. So people generally know this, but just want to reiterate, put in comments occasionally that are just completely irrelevant to the software. So if somebody is using your source code, you'll be able to find them and identify that it came from you. There's no reason why you should talk. There should be one line with your grandmother's full name, on page 80 of the source code. And also insert errors in databases occasionally. So if somebody takes your database, you can prove that it was your database and they just didn't create it on their own. Google Maps there's tons of examples of this. I just put this one example of Google Maps up there, that there's a town in Google Maps in the middle of Palo Alto that does not exist called Neil, but you have to be at the right zoom depth to actually see it, shown here on the right. But this exists throughout. It's not like this is the one example they have. If you know areas in Google Maps and you start looking very discreet, they obviously don't want to put in so many areas it distracts people from use of the product. There's enough in there that you can unquestionably prove that somebody stole your database. And that's it. So I'll be happy to take questions if there's time for that. I know we're kind of running over here.
Wow, I must say, David, this has been extraordinary. You and Jonathan covered a whole new area that we usually don't think about in academia. I'll let it's also very I'll let any of the scholars ask questions if they have. They must be exhausted. They have been in this since 8 in the morning. And any scholars have questions? This is not what you can imagine what we do on a daily basis.
Yeah.
And it's
Oh, I'm sorry to cut you off. Just to be clear, just like John mentioned at the end of his talk, I'm happy to take questions over email later on if people have any.
I was just going to mention that I had a question, but you answered it that very last slide. So I was wondering how, if you're going to do a dual license, how are people figuring out, the folks that are on the private, sector side using their code? But that makes a lot of sense. You put these, I was thinking, how do you put the Trojan horse in? But all of your ideas seem to work, or seem plausible. So thank you for that.
We have one question from Astrid.
Hi, question. So it seems like you highlighted throughout your presentation that a lot of issues can be resolved or avoided by involving legal help earlier on in these startups or these entrepreneur ventures. But what are the resources for junior researchers who may not be as well funded or connected to legal entities who can help out with these issues as these processes or as this venture develops?
Oh, that's a great question. There are the first thing that comes to mind is there are a number of universities that are trying to set up legal clinics, or I shouldn't say trying to, they are up and running legal clinics for early stage companies that are pre-funding, especially to at least address freedom to operate issues, but also sometimes the patentability. I mean, your tech transfer office theoretically would take care of the patentability side of things for you to some degree, but understandably, they're not involved in product development directly, and so they may not want to touch the freedom to operate as extensively. But I know, during my introduction, Vivek mentioned that I'm working with UCSF College of Law on their startup legal garage. That's exactly what they do. They get law students to work on legal IP projects. And the original focus was freedom to operate, but now they've kind of opened it up where the students can work on some patentability to some degree and some other IP issues. I know UC Berkeley's law school has a similar project in their clinic. And I think there are others as well. I obviously can't name every single one of them, but there are a lot of those out there that would be good resources. Of course, you kind of, there's the cynic in me says you get what you pay for. I mean, these law students are supervised by attorneys. I've supervised them. And you do get a lot of time out of them. And they're generally very smart people, but they just, they don't have much experience. But they'll produce something for you that is better than nothing. And you'll get, the one thing they can do is they can search. And that's really the foundation of understanding a lot of this stuff. They can get a lot of good search results. But there are other resources too. That's the first one that comes to mind.
Yeah, I was going to jump in
Thank
with
you so
that
much.
startup legal garage because if I remember right, Jennifer Doudna herself, a Berkeley professor, came to the startup legal garage to patent the CRISPR technology. So I probably, and you were a recommendation by their team. So I'm glad you could join. I'm glad Jonathan could come because you've actually pushed us into dimensions we should be thinking in today's times, and hopefully there will be more interaction once we start processing all that was shared and watching the videos in slow motion.